You know what my answer is going to be, right? It depends.
It's up to the board.
It depends on what the board's rules of procedure are. And for the kinds of boards that we're talking about, you can get very complicated with things like charters and such, but you all are creatures of statute, and for the most part, except for things like the Brown Act, you're allowed to set your own rules of procedure. So you could adopt a procedure as a board, a majority of the board could adopt a procedure that says the president of the board may not serve for more than 2 consecutive terms, and terms a year. So you could do that. You don't have to do that. Any other, I see another hand.
I listened to the board mention micromanaging, but if micromanaging wasn't really explained to the extreme, is there anything that...
Well, micromanaging is, I guess, the opposite of what was being recommended to you.
Let me give you an example. A good example of micromanaging is the difference between going to a board meeting and saying, okay, our policy now is to pay all the district's invoices within 60 days. And so you set a direction and you instruct the staff to do that. That's a general guideline. That's something the board should be doing. But what you shouldn't be doing is, as an individual board member, then going down to the facility, demanding to see all the documents there in the accounting department and sitting next to the bookkeeper and watching her as she writes out all those checks and questioning each check as to whether it's within 60 days or not, or whether it's an appropriate expenditure, or whether you're over or underpaying it. And there are board members that do things like that. And that's really not your job. That's the bookkeeper's job and the auditor's job at the end of the year to make sure the books are all square. That's micromanaging. That's an example.
And that's not illegal.
Yeah.
But it is a really good way to become the focus of a harassment or discrimination claim or a workers' compensation complaint due to stress. So it's generally a bad practice, and it may expose the district to liability. That doesn't mean that you as a board can't say to the district manager, for example, we would like a report on how often the board's policy was met regarding 60-day invoices, to use that example, and then you get a report saying we hit that 93% of the time. And you say, well, we want to hit it 100% of the time. That's perfectly appropriate. It's just not appropriate to show up in the office and, rifle through the mail. And there are district board members and other board members who do that sort of thing. Showing up and making threats to individual employees regarding their jobs or their job security, that kind of thing is micromanaging. And so it's essentially the opposite of the code or the course of conduct that was being recommended that you follow, being a team player, setting direction, etc., rather than telling people we should put these in the red box and these in the green box and these in the yellow box. That's not why you were elected or appointed to that board. You have employees that are supposed to do their jobs, and your job is to set the policy direction. Do we have any other questions? Going once? Going twice? Going. Oh, wait, we've got one more.
I'd like to know how or what would be the best way to handle, letting the townspeople know what's going on in your community, but what's the best way to handle your board being threatened?
Do you mean threatened, like physically threatened?
Physically threatened?
Oh, that's a
What's the best
crime.
way to handle this? Because, you got a good board that's all working together, but yet you had a rogue board member from the past that's on his little bandwagon, so to speak, in my opinion.
Well, if political threats are one thing. Political threats are, I'm going to run against you and I'm going to beat you. That's a matter of free speech. If you're talking about physical threats, I'm going to burn your house down, I know where you live. Those are called, that kind of thing. Yeah, those are called terrorist threats. And it's a crime to make those against any public official or employee. And you would call the police or the sheriff's department or the district attorney's office.
District attorney? Okay. we've had, numerous things left in the post office, wasn't real good. It's all been, every time we've got that, it's been reported to the sheriff's department. But it always seems like it comes back at us, that we're the people making the complaints against, or we're harassing the individual. And we're,
Well, it's not you. I mean, all you do is report it to law enforcement, and then they will do a criminal investigation. Whether there's enough evidence to sustain a criminal charge, I couldn't comment on that because I'm not a criminal lawyer. There is another option, and that is any employer, not just public agencies, has the ability to seek a workplace violence restraining order. And it doesn't mean that the person has to have actually been violent, but they may have made threats of violence. And the county has a workplace violence committee, and we are convening not less than once every month for some sort of threat of harm to one or more public employees. And in that case, the standard of proof is different. It's not a criminal standard of proof beyond a reasonable doubt. It's a civil standard of proof, the preponderance of the evidence. And the result of that is that the person restrained, let's say it's a disgruntled former employee, for example. The person restrained is prohibited by the court from engaging in certain kinds of behavior. And many of you are probably familiar with those kinds of orders, most often in domestic cases, where they're called stay-away orders. You have to stay within so many feet. You can't go to certain places. You can't call a person on the phone, that kind of thing. Those you can also get in the context of the workplace. And like I said, we get them a lot. Those most often come up, in my experience, in actually a domestic context, in that an employee of the agency is in some sort of failed relationship, and their former partner is making threats and is doing things to threaten them at work. In one instance, for example, the former partner showed up and disabled the employee's car in the employee parking lot. And of course, you might say, well, that's a domestic issue. But if someone is going to come in and try and kill you because they know where you work between 8 and 5, they know where you're going to be, they may not just shoot you, they may shoot 5 other employees. It's a matter of safety for all of the employees, or in some instances, officers of the county. And, absolutely, it's one, potential terrorist threat, a criminal act, and 2, possibly the basis for a workplace violence restraining order. And to do that, you would need to contact your attorney. It's not a real complicated procedure, but it's in legalese, and there are forms and court appearances that have to be made.
thank you.
Does that help? Okay. I'm going to say, one more.
I have one last thing. What could you suggest for us to do? Our secretary passed away probably 2-3 years ago, and after she's passed away, we've found things to be just a mess. Okay?
You mean your
Bylaws.
Your board secretary, is that what you're talking about?
Yes. Bylaws are nowhere to be found that were once, I guess, implemented. What can be done? What do we do?
Well, first of all, call your attorney. You can also call the Special Districts Association, and they have some assistance that they'll offer to you, either in phone or online. You may have to start over. If something is just gone, and that does happen, in particular in smaller districts, your statement of finding things are just a mess, and you have people that serve in a position for year after year after year. It's not uncommon, for example, for people in that situation who have kept records in their home, and one day there's a flood in their garage or something, they literally are gone, they've disappeared. You may just have to start over and pass new bylaws, new policies, etc., to take yourself forward, and then include in those that this policy, this procedure, these bylaws supersede anything previous. Because you're not magic, you can't create something out of nothing. In some instances, but not all, you may find there are other places where those documents exist. Sometimes the local libraries keep copies of all sorts of things that you wouldn't think there are copies of. In this day and age, it's not at all uncommon to find things now on the internet that you had no idea were there, that anybody can put them on there now. And occasionally, it will have been attached to, say, correspondence. Like, enclosed for your records is a copy of our bylaws to the Board of Supervisors, if that's your appointing authority, for example. So there may be a duplicate somewhere. But if you've exhausted all those avenues, you just may have to start from scratch. Nathan, do you have any other magic ideas? No, apparently not. Yeah, start over.
Okay, because we've tried to contact, because we have a new attorney, and we've tried to contact the previous attorney, but nowhere's to be found.
Well, the state bar can actually help you there.
Okay.
If the person is still alive and in contact with the state bar, that is, they're either in active or inactive status, so the state bar has their address, they can actually assist in tracking that person down. You can find, if you have the name of the bar member, you can find that person on the state bar's website, and it has their most recent contact information. But sometimes the state bar can be more useful. What do they call that? Is it an ombudsperson? It happens. Sometimes lawyers just die, for example, in the middle of they expect to, and what about their cases? What about their files? So there are procedures that the bar has in place to assist clients in recovering their documents, things like that, if they still exist.
Okay, thank you.
You're very welcome. I'm going to say, going for the last and final time. Thank you all so much.